Good morning and good evening, everyone. My name is Niv Tadmor, and I'm the president of IFA Australia. On behalf of the IFA Australia, I welcome you all to our session today. I begin today by acknowledging the traditional custodians of the land on which we meet today and pay my respects to their elders, past and present. I extend that respect to Aboriginal and Torres Strait Islander people here today. IFA is essentially about bringing top experts and cutting-edge tax issues together, and today is a very good example of that. It's about soft taxation and intangibles and beyond. So with that, I will hand over to Ben to start the session.
Thank you, Niv, and welcome everyone today to today's discussion on the future of software taxation in Australia and beyond. For those who don't know me, I'm Benjamin Lancaster and of Counsel in Jones Day's Australian tax team based out of Melbourne. So to set the scene for today's panel, the catalyst for this discussion was the Australian Taxation Office's, the ATO's, release of draft guidance on the characterisation of receipts in relation to software. And this was the first guidance that the ATO had released in that space since 1993. And it's just one part of a broader discussion about how the use of intangibles are taxed and how the use of intangible rights should be taxed. And it almost goes without saying that the world of technology has changed dramatically since the guidance in 1993. Indeed, the idea of meeting virtually like we are today was little more than a pipe dream at that point in time. And there's a whole range of new ways of doing business online and using other technology that nobody could have foreseen back then. That time has also seen dramatic changes to the world of tax. The OECD's guidance on these issues and on many, many other issues has been comprehensively updated over that more than 20-year period. Even more recently, it appears that we now have a global consensus around fundamental changes to the taxation of large multinational companies. In particular, the OECD's Pillar 1 and Pillar 2 proposals that do seem to have found that broad consensus. Now, coming back to software, characterizing payments in respect of software requires consideration of complex issues of both tax and copyright law. And it's, I think, uncontroversial that a payment for the use of copyright will be a royalty. However, identifying what that use is and what a payment is actually for can be challenging from both a tax and copyright perspective. So before I introduce the panelists today who are tasked with untangling all of that complexity for you, just a couple of quick housekeeping matters. Firstly, we certainly do encourage audience participation in today's session with questions, which you can submit to me through the Q&A of the chat function in WebEx, and you can either direct those to me publicly or privately. And then secondly, I'm mindful of leaving enough time to address the questions. We won't have much, but there will be some. So I apologize in advance to both the panelists and to the audience if I jump in to try and keep the session moving quickly. So to come to our panel, our first panelist is Assistant Commissioner Chris Ferguson from the ATO, who's responsible for strategic case leadership in the ATO's public groups and international business line. Chris will be familiar to many of you on today's call, as he's played a leading role in much of the ATO's work on intangible arrangements in recent years. Indeed, Chris has the fortune, or perhaps misfortune, you'd have to ask him, of being named as the contact on this draft guidance and on the ATO's recent practical compliance draft guideline on intangible arrangements more generally. Secondly, we have Megan Funkhouser, the Director of Policy, Tax and Trade at the Information Technology Industry Council, based out of Washington, DC. Megan has worked with the ITIC's membership in relation to these issues that we'll discuss today and how they've been approached around the world, and has a range of insights that she can share with us from that experience. And then lastly, but certainly not least, we have Miranda Stewart. Miranda is a professor at the University of Melbourne, a member of the committee of IFA's Australian branch, and vice chair of the permanent scientific committee of IFA globally. Miranda is incredibly well versed in the history and evolution of the tax system and treaty frameworks, and today's discussion will certainly benefit from that knowledge and experience. So to kick off, I might direct my first question to Chris and ask him to take us through what has prompted the ATO's decision to update their guidance in this space for the software industry, what's changed, and perhaps more importantly, why it has changed.
Yep.
Chris?
Thanks, Ben. And very, very happy to have my name on the PCG in the tax ruling. And look, there has been a number of discussions with probably many of the participants And we really have encouraged those discussions, and we really will continue to encourage the discussions because, as many of you would be aware, we're undertaking a little bit of an unusual approach with this software ruling in terms of going to do a revised draft and do another round of consultation. So we think that the ruling and the eventual position will really benefit from continued consultation. Going to the question of why now was the time for the ruling, I think Ben, you sort of led with some very relevant opening observations about the passage of time between the early 90s and sort of what we do today and how business is run today and the business models of today. And during the early consultation with the first draft, industry really was sort of seeking some more contemporaneous guidance from the ATO and really asking for guidance to be based more on what they see as being the current day distribution models or the current day business models for facilitating the supply of software in numerous industries. I think if we look and say, well, why do we need to change? I think there's some utility in looking at what we saw 9312 as actually providing guidance on. And I think really 9312 really did focus on sort of the reproduction and modification of software, and which we also saw in 9312 the concept of simple use sort of being articulated by the ATO, and we really saw simple use in 9312 being sort of that role where an end user will make a copy, and that's for the end user to effectively use the software for its intended purpose or its commercial purpose. As distinct from an end user using the copyrighted article or the copyright that exists within the software. Really, we did see in 9312 a bit of a division between sort of the use, so the license to use copyright, and that can be sort of seen in paragraphs 18 to 20, and particularly in paragraph 20, where the ruling really did talk about when you're looking at and determining whether or not there is a royalty, what we were asking there is that you really need to make that distinguishment between the use of the copyright itself and then the use of the program. And I think what we would say is that the new taxpayer ruling does little to sort of disturb that concept or that principle in terms of saying, well, let's start by having an analysis of the rights that are exchanged, and ruling. And the ruling will also preserve that simple use concept where we're looking at it from the end user's perspective, and the end user is really using the copyright for its design purpose. I think where the ruling needed to be addressed was really more in relation to the license to use software. And we can see there that sort of in paragraphs sort of 26 to 29, we can see where that concept of simple use had been sort of established. I think where 9312 sort of had a gap or a gap of guidance was really, we think it predominantly more focused on the end user, so the end user experience and the payment or the receipt resulting from the end user, and did not necessarily really reflect what a payment or the nature of the payment from an intermediary to sort of the copyright owner or the IP owner. And I think we can see that really that the focus of 9312 was probably more informed by the current day distribution models, and we really do see sort of a heavy focus on the shrink wrap model, and I think 9312 really might have been sort of even contemplating that shrink wrap model in a scenario where sort of the conveyance of the rights, or there might be a sub-licensing of that shrink wrap function, and we didn't really see that, and we don't see that as being sort of a current day distribution model. So I think in terms of Ben, what we think has changed, well, clearly we think the distribution models have materially changed from the early 90s, and we do see a greater presence and a more use in multiple industries of platform-based distribution, and that platform-based distribution could be tangible goods, intangible goods, and also services. And we also see other distribution models and business models which include cloud-based consumption. I think what has also changed is that, as you mentioned, Ben, at the start, the world of technology has changed, and the use of intangibles in business has changed, and how businesses go about recognising intangibles and the value that they prescribe to intangibles in business has also changed dramatically. So from an administrator's perspective, our task is not necessarily to provide a ruling and approach which is specific to software. Our task is necessarily to have a principle-based approach where we can administer some of these issues that we do see across multiple industries and have a degree of consistency in the way that we go about it. And really what that sort of positioned us is saying, well, we think that it's quite essential that in the new ruling and how we look at intangible arrangements going forward, we really do adopt this initial rights-based approach, and it's really to look at the exchange of rights and how those rights sit across the payments, and really trying to characterise those payments and identify what component of those payments are for use. I think, Ben, at the start you said it's sort of a bit of a complex web, and it might not be disputed that a payment for a copyright is in the nature of a royalty. And we would agree with that, but we would also agree with your following comment that the difficulty is probably not at that first hurdle. The difficulty is probably about these concepts around use, apportioning undissected payments, and really trying to allow people to have some sort of clarity in terms of saying, well, I can understand what the ATO's view is on these transactions, and I can also understand how the ATO is sort of going to look at my transaction. And so what we would say is that I think the ATO's work in intangibles is much broader than just this taxpayer ruling, and I think where we can see the original concept and the original principled approach of the ATO really probably first started in the Taxpayer Alert 2018 too, and that was a transaction or a series of risks around transactions where we did see a number of valuable intangible assets not being appropriately recognised for Australian tax purposes, and these arrangements were commonly called embedded royalty arrangements, and often the fact pattern of those was there was a single undissected amount, and included in that exchange was some valuable intangible assets. So we think sort of there's a suite of guidance in terms of that Taxpayer Alert, the PCG that you referenced, Ben, and now also the software ruling, which does have a more facts and circumstance focus on software industry and distribution of software. But we would say that those guidance documents suggest that this is the approach, and not only the position that we think is correct at law, but also the compliance approach that the ATO is more broadly taking to intangibles arrangements.
Thanks, Chris. That's really helpful background on where the ATO's position comes from and how software fits into the much broader puzzle. From the perspective of software, Megan, I might ask you how similar or how different the ATO's rights-based approach that Chris just spoke about is to the approach taken in other countries and the broader international treaty framework that exists as well.
Thanks so much for the question, Ben. And also first, thank you to IFA for inviting me to participate in today's discussion. And thank you also again for the question about how industry sees ATO's perspective in contrast to what's happening around the world and what has been the global tax norms in this respect. So as Ben mentioned at the top, my name is Megan Funkhouser, and I lead on international tax policy for the Information Technology Industry Council, or ITI. Founded in 1916, ITI is a global trade association that represents 80 of the world's most innovative companies across industries such as hardware, software, services, platforms, cybersecurity, and related industries. We're based in Washington, D.C., where I am, but we have an office in Brussels and presence in Delhi, Beijing, Seoul, and Sao Paulo. I bring this up not only because we're proud of our membership in our organization, we are, but also because it demonstrates ITI's emphasis on taking a global perspective on the many policy areas and industry standards that we focus on. These are the ones that advance competition and innovation worldwide, including taxation, which brings us here today. So as I mentioned, a lot of our companies are at the forefront of software. And so the classification of computer software payments is one we watch closely, and it does enjoy a general consensus among countries to distinguish between payments for acquiring copyrighted articles, so i.e. business profits, and payments for exploiting copyright rights, royalties. And a payment for the use of or the right to use a software copyright is a royalty. And a payment for the use of a software program copy, which is standardized across all potential customers, is not a royalty. It's just as a payment for a physical or electronic book would not be a royalty either. So taking it a step further, the classification of software payments should reflect that software copies sold without the use of or the right to use a software copyright right should be subject to net basis taxation in accordance with Article 7 of the OECD model. And this classification should not change whether it is a software copyright holder or a distribution intermediary. So I brought up briefly the OECD model, but paragraph 14.4 of Article 12 of the commentary of the 2017 OECD model applies this logic as it acknowledges that, quote, distributors are paying only for the acquisition of the software copies, not to exploit any right in the software copyrights, end quote. And so therefore, you would see these relevant transactions treated as business profits under Article 7 and not as royalties. So I think where you see the difference here is that because a distributor's, as the global tax norms go, a distributor's income arises from the activities related to distributing software copies, where a software copyright holder derives income from activities related to the exploitation of software copyrights. A distributor is not paying for the quote, the right to stand in the shoes of the copyright owner and exploit the copyright in software, end quote. And this is a quote that came from the draft taxation ruling. And I think it illustrates in our mind that there is a difference between what the distributor is paying for. So the distributor is also not paying for the right to use copyrights. Instead, the distributor is paying for the right to distribute, which enables the distributor to derive income from the sale of software programs to end users. And so the right to distribute itself is not a copyright right. Chris had brought up, and Ben brought up 9312, and to date, the Australian government has demonstrated its commitment to distinguishing between the usage and the exploitation of software copyrights as enumerated in 9312. And I think this raises one of industry's core questions about the draft taxation ruling is like, what are the implications of a change in domestic interpretation on Australia's bilateral commitments with more than 40 jurisdictions around the world? And I think it's well known that Australia is negotiating more tax treaties as of now. And so to the best of our knowledge, and I can go into more later, but we're not aware of another jurisdiction that has implemented this approach to the characterization of certain software payments, whether through bilateral tax treaties or due to reinterpretation of domestic income tax and or copyright law. We do understand that ATO has been having conversations with counterparts around the world about this approach. And we, I think, are very interested to see how those conversations are going given Australia's bilateral tax treaty commitments, and that there is a global tax norm as to the treatment of these software payments that should be protected and continue to be upheld as described in the commentary for the OECD model. With that, Ben, I'll turn it back to you.
Thanks, Megan. And those are certainly important points around how this fits from a global perspective. And I might throw to Miranda with a similar question to what I asked Megan in terms of, well, how this fits with the international tax framework and how that framework has evolved over time to get us to where we are today on the taxation of royalties.
Okay, yeah, thanks. Thanks, Ben. And thanks for having me on the panel. So, what's so interesting about this being raised now is that it actually takes me back to when I was in New York in the late 1990s, and there was a lot of controversy in the US and a lot of attention being given to the issue of the new regulations on computer software and how to treat it, shrink wrapped or royalties and so on. So, and it is interesting too that the new ruling is replacing a 1993 ruling. So we're sort of 20 years later looking at the changes in the way that these things are supplied and so on. But of course, the concept of copyright hasn't really changed since I guess the 80s and the 90s. And just to put that in a little bit of context, Ben, without spending too long, in Australia, of course, the Copyright Act was quite old, but there was a case involving Apple, actually, Apple software, about whether there was copyright in a computer program in the 80s. Actually, the courts found that initially that there was not, and then subsequently that there was only a copyright in some particular limited ways. And so the Copyright Act was amended, and that sort of happened in many countries at that time, as Megan had mentioned, that to protect copyright as a literary work, basically, in software. So we're sort of under that general law, and both the treaties, of course, and Australia's domestic law refer to, they don't define copyright, so they do reference that general law, which has, again, subsequently been updated. So that you've got this key question of what does it mean to say that there is an amount paid as consideration for the use or right to use a copyright, and that's really the phrase we're interpreting. That phrase is pretty old. It's it's sort of been in our statute for quite a long time, and it's been in the treaties for quite a long time. So that's sort of one part of the history, but of course the mode of distribution and delivery and kind of mass provision of software, copyright software is really different, and that's what people are grappling with now, I think, is what approach to take. The other bit of history that I think might be useful, Ben, is to think about Australia's treaty or sort of international tax policy approach to royalties, and in fact that has changed over time. So Australia, historically a capital importing country, we had a treaty model, especially in relation to intellectual property and royalties, which was much more along the lines of the UN model treaty, emphasizing source taxation, higher royalty withholding tax rates, broader definition of royalties historically. And in fact, if we again think about the US treaty, our first US treaty, or not, the treaty of the earlier treaty, going back to 1983, and not the very first one, actually has that older definition of royalty in it, that UN approach, with a very sort of expansive sort of list of items, but still, of course, talking about use or right to use, copyright, that phrase is in there. The protocol that amended that treaty in 2003 shifted Australia's policy to the OECD model, right? To the model that, as Megan has said, countries are using, because comparable countries are using, and so we sort of moved away from that. So we have, in some sense, historically diverged in some ways Australia's tax policy approach to royalties and copyright, right? But we have also then moved into the OECD approach, which does imply, to some extent, a narrower taxing base for royalties and lower rates than historically. None of this, I guess, really answers the question about how you should interpret the phrase use or right to use, but I think it is important to put that in the broader context of our treaty policy in terms of taxing these things. And I think Chris already referred to the idea that this is not so much just about software and royalties, but about intangibles more generally and intellectual property more generally and new approaches. Ben, I might leave it there, and you can kind of come back with.
Thanks, Miranda. I think it's certainly very important history, and it's interesting that in many respects, software is newer than tax treaties, and we're sort of retrofitting software into the existing tax and copyright law concepts. Chris, I had intended fully to give you a right of reply on this one, but I know you missed part of that. Obviously, paragraph 14.4 of the OECD guidance is something that a number of people have raised in this space, and I know you've got a particular take on that. So yeah, over to you.
Thanks, Ben. A suspicious mind might suspect that people didn't like my views, so I was kicked out. But I'll push on. I think post-release of the software ruling, as Megan said, we have been having a number of discussions with a number of jurisdictions, And I think what we've sort of known and what's sort of been confirmed is that there are rather sort of two schools of thought, which are informing the outcome when you're looking at this question of the use of or the right to use. And I think what we've seen is that the guidance that is currently out there, and yes, you know, whether or not the guidance is currently was drafted or is still relevant in terms of the current day distribution mechanisms, that's something that we are having discussions with. But I think the guidance from various jurisdictions is largely informed either by adopting a similar rights approach or by adopting sort of what we would describe as a bottom-up approach, where it's largely sort of what is described as an essential nature approach. And we have seen some of the guidance from other jurisdictions really sort of take a strong lead by what is the end user experience and sort of what is the experience for the end user. Now, I think we don't necessarily think that's the right approach, and we, as I said at the start, in the broader concept of intangibles, are adopting a sort of an initial rights approach and looking to apportion the amount to identify what a portion of a amount is for the right to use. And I think we sort of take comfort in that 14.4, which has been really of central focus for a lot of our discussions, clearly won't apply to a transaction where there is a right to reproduce the software. So we would say that 14.4 necessarily requires you to first consider whether or not there is a right to reproduce software. And that can't be informed by what the end user experience is. So, and we think, whilst we think that 14.4 potentially still has application to current day distribution models, I think what questions we're asking when we're looking at some of those transactions and the discussion that we're having with taxpayers in this space is that where we see a fact pattern where the end user license is sort of granted by not the intermediary, and where we see sort of the fact pattern where the intermediary is also not having a right of reproduction, a right of adaptation, and probably more relevantly today, a right of communication. We are sort of left questioning, well, and what is in fact that entity paying for, particularly where it's sort of in a more current day distribution platform or a software as a service scenario. So I think we would acknowledge, we definitely acknowledge 14.4, but we think it still sits consistently with the approach that we're adopting. And I think sort of obviously we would point to other sections of the guidance as well, which we necessarily think are sort of mainstay points of the guidance. 13.1, we think, you know, clearly 13.1 is although after the 9312 adopts a similar sort of approach as communicated in 9312 in terms of looking at the rights and looking at what whether or not the intermediary has rights which would otherwise be that of the copyright owner. And I think the approach that we say in respect of how we're working with other jurisdictions is that that's a continued engagement and a continued discussion. So we're not sort of we're not minded that we're just going to sort of push on ahead without having a view of how we would discuss these disputes, which will inevitably arise, particularly when we might be getting to the question of apportionment.
Thanks, Chris. And I think that apportionment question is incredibly central to what we're doing, and I know that's something we'll come back to later today. To jump away from the international treaty framework, I might ask Megan just whether you can share some of the industry's other comments on the approach taken by the ATO in the draft software ruling.
No, of course. Well, and first, before I walk through industry's reaction, some of which I covered earlier, I also want to give Chris and his ATO colleagues public credit for being open to answering industry's questions and walking through their thinking. I think this is an example of it, this event, but I've also appreciated ATO's willingness to speak to us and talk about the ruling. So very much appreciated. And like I said, appreciate the opportunities for engagement for so far. And then we're also, of course, looking forward to engaging with the next draft taxation ruling. Our submission and our follow-up engagement has generally fallen into two buckets. One is the more policy or substantive considerations, and the second one is more of the administrative or the technical considerations. The policy boils down mostly to the global tax norms I described earlier to distinguish between payments for acquiring copyrighted articles, business profits, and payments for exploiting copyright rights and royalties. Whereas ATO is leading, as Chris mentioned, with a rights-based approach, industry is focused on the experience of the end user. There have been significant innovations in how we deliver, but regardless of whether software is delivered via cloud services, SaaS, software as a service, digital download, or physical copies, if the characterization of income from that software payment should be consistent if the experience of the end user is the same. Paragraph 14.1 of the OECD commentary makes this clear by stating that the method of transferring the computer program to the transferee is not relevant. And again, this underlying rationale for character classification holds true whether or not the payment arises from a software copyright holder or a distribution intermediary. Because I spoke some to the global tax norms before this, I did want to spend more time talking also about kind of the administrative and technical considerations that came up as part of the draft taxation ruling. So this is a proposed domestic reinterpretation of what constitutes a royalty for the purposes of classifying certain software payments by distributors and resellers. However, this would have implications for Australia's double tax agreements, both inside terms of we see the potential for increased disputes, as well as double taxation. In particular, our expectation or our hope would be that a newly adopted domestic reinterpretation would have no bearing on the traditional interpretation and application of the royalty definition and other aspects of the royalty article under all existing Australian income tax treaties for the previous tax periods and for future tax periods while such treaties continue into effect. As Miranda walked through, these have been, the tax treaties have been in law, and so that's what companies have been relying on for their engagement with that market. Last but not least, I'd also like to bring up the dative effect. The draft ruling states that this change would be effective, quote, both before and after its date of issue. Except in circumstances where doing so would conflict with the terms of settlement of a dispute. So writ large, a retroactive tax undermines the principle of tax certainty and exacerbates compliance burdens. And this would be even more acute here for a case where the ruling would take an approach at odds with the global consensus on the characterization of software payments. And so prospective effective dates and sufficient transition time would provide companies with the time to design, develop, and test the requisite compliance systems, adjust end user license agreements, and otherwise feel as confident as possible when it came to their decision making. So our companies have been making decisions and relying on the guidance in 9312. So if or when ATO advances a relevant ruling, the 9312 guidance, we believe, should apply through the taxpayer's tax year that includes the revocation of 9312. As a final point, we also understand that Australian tax administration law makes clear that if a public ruling is withdrawn, that public ruling should continue to apply to schemes to which it applied that began prior to the withdrawal of that guidance. So it's one of the areas where we'd also appreciate greater clarity in the next draft ruling would be with regard to a more prospective, effective application that would also involve a transition period to account for how, again, we have our substantive concerns, but if ATO does move forward with this approach, then companies would need significant amount of time to be able to design the systems to comply and to really have that solid working relationship when it comes to these taxes. So Ben, I'll turn it back to you.
Thanks, Megan. So I might ask Chris for your take on those issues and the feedback you've received more generally, but in particular, I think a couple of things that Megan has hit on. Firstly, that the ruling is expressed as being about the domestic definition of a royalty rather than any particular treaty definition, and how it's expected that this guidance will be applied in a treaty context, and your take on how the rules that mean that the old ruling from 1993 will continue to have effect will play out going forward.
Yeah, sure. Thanks, Ben. And I think it's probably useful for me to sort of provide a more overview as well in terms of the general feedback that's been provided in respect of the software ruling and also how we've taken on board that feedback and what we're sort of proposing to amend in terms of the ruling. So I'll start with saying we're not proposing to amend our rights-based approach. So that might be a disappointing place to start for some. But I think the other feedback that we've got is the points that Megan's raised, and we have greatly appreciated the ability to speak with industry about those points. But also what we've really seen is that I think when we were trying to identify this principled or the rights-based principle approach, we tried to adopt a simple example approach and try to try and pull out the principles from quite simple examples. I'll admit that we probably didn't really hit the mark in terms of doing that, because inevitably when we have discussions with people, it immediately turns into quite a facts and circumstances scenario, and quite clearly there's quite pivotal facts or there's quite pivotal rights that would be exchanged, which will tip the conversation in either direction. So really, in terms of the next draft of the ruling, we really will sort of do away with some of the examples and come back with examples which are more granular. So there'll be examples where we're actually saying these are the legal form rights that are exchanged between copyright owner or copyright article owner, or the copyright owner and the intermediary. And then also we will also speak at a more granular level about what actual substance function is being performed by the intermediary as well. And we see sort of, you know, that often discussed debate about substance and form as being quite critical when going back to that question of apportionment and making a determination about whether or not there is a right for the use of software and the extent of use of software in that concept. Retrospective application, as you mentioned, Megan, the reason that the ruling has retrospective application is because we already have taxpayers adopting the rights-based approach, and we have been able to be engaged in discussions with taxpayers and seek resolution in respect of the approach which is communicated in their ruling. What I think the challenge for the ruling will be in the explanation section is to really sort of communicate what we think is reasonable reliance upon 9312. As I sort of suggested at the start, we have seen that concept of simple use. And if you look at it in the context of 9312, it is often caveated as being a solely in respect of the payment from an end user, or solely in respect of the business model, which is shrink wrap distribution. And I think we would really struggle to think that there's reasonable reliance where you might have an intermediary which is performing and holds the rights to sort of communicate or provide the service of cloud computing or a distribution function. We really think that we don't think that it's an immediate thing to say that where you're running a distribution platform, you're effectively, in terms of that intermediary function, you're performing the same function as someone who is actually distributing a tangible good. So we think that that's where the discussion needs to be had about how reasonable there is to have reliance on 9312. And obviously the other thing is that people have really sort of requested for the ruling to provide some examples about how the ATO would view the task of apportioning a undissected amount. And I think that's where there's likely to be sort of taking a bit of a potential disagreement between sort of the parties, whereas I think at the moment the ruling could be read as saying that the ATO's approach is to identify a right, and then effectively, once the ATO has identified that right, the entirety of the amount is a royalty. Now that's not our position, and I'll accept that might not be as communicated as well as it could be in the current form of the ruling. And so what we would be looking to do in the ruling is providing an example where we can see that this is where we would go, this is our process, and this is what we would result in terms of an outcome, in terms of saying, well, we think this proportion of that amount is properly allocated to the right, and the right is in the nature of the copyright. And that's how we think that we might be able to provide some greater clarity as compared to the examples at the moment, which are quite simplistic, and the reader could arrive at the conclusion that the ATO is saying that the entirety of the amount should be characterised as a royalty. So in terms of what the next version of the software ruling will look like, we'll obviously, as I said, revisit all of the examples, and we will put some commentary in terms of what we think is reliable, reasonable reliance on 9312, and then also we'll make some observations about whether or not we think that the ruling is aligned with the current OECD guidance.
Thanks, Chris. I certainly think you're taking on a formidable task there of trying to come up with an example of how the court would apply or how the ATO would apply the principles around apportionment. I might ask Miranda actually for your thoughts on how a court might go about that task of trying to apportion payments that are very commonly dissected in arrangements between both related and unrelated parties.
Yeah, it's it really is a bit of a tricky question, isn't it? I mean, we've got in the statutory definition, of royalty, and also in the treaty rules where it appears in the treaties, we do have that apportionment rule there. So, we do have that explicit guidance. People who know about Australian income tax law more generally in the audience will know that there are circumstances in other parts of the income tax law, not so much specifically about royalty, where this question of when and in what circumstances you can apportion a payment with reference to what it's for, what the contract said, what the parties intended, what as a matter of kind of legal intention and substance, if you like, not so much economic substance, but legally what is really intended for the payment. It's not always a straightforward task. And there are circumstances in other parts of our income tax law where our federal courts, which also administer copyright law, in fact, are reluctant to apportion unless, as you say, this sort of there's this phrase of sort of undissected lump sums, which is something in the Australian income tax law which comes up from time to time in different contexts with potential problematic outcomes because you can't identify what that particular part of the payment is for. So, I mean, I suppose one possible consequence of the ATO moving in this direction, as Megan said, if this change is pursued in some way, this sort of change in approach, is that it may mean that industry and contractual relationships with distributors and so on need to be more explicit about the way that the payments under those distribution agreements are managed and defined, and what actually is being paid for. That might be something that has to be considered. I thought it is kind of, I just might make one comment. I'm certainly not an IP lawyer, but I have had a couple of conversations with colleagues and had a bit of a look at it as well. And I must say Australia's courts are perhaps a little different from some courts elsewhere in the world on copyright as well, and perhaps a little different from the US. And although we're talking about tax, again, we sort of have to bear in mind that context, especially because the same courts are federal courts who administer both copyright law and tax law. Unlike, so in the US, I'm sort of aware that, the provision of an ebook, for example, I think Megan, you referred to that example, seen as a kind of sale of an article, more like just that business profits context. It's not 100% clear to me that an Australian court would take that approach in the copyright law context, that they are pretty strict on royalties and licensing. And the language, of course, is to sort of commercially rent out. It's a slightly different language from the language we would normally use when we think about licensing royalties, but that's the sort of copyright language. So I just want to throw that out there as sort of a possible influence on thinking about this. And look, just finally, it's good to hear that the ATO is thinking hard about for those who have relied on TR 9312. Obviously, it's a pretty important part of Australia's tax ruling system that taxpayers do have that certainty. That is the point of the ruling system. And so I think managing that transition, if there is any change, is pretty important.
Yeah. And I think, Miranda, the point that you raised, which we fully expect, is that an industry reaction will be to review and consider whether or not the legal form or the exchange of rights actually aligns with the substance of the transaction or sufficiently depicts the transaction. And I think that has long been sort of an expectation of the ATO. And I think what it reflects is that it's a pattern of behaviour that we've seen in many industries, and I would say that I think the software industry has sort of been better at doing it because potentially they've had longer in the game in terms of intangible assets and how you would go about documenting the exchange of rights. But I think some of the ATO's communication in terms of the PCG around intangible assets, the biggest risk that we sort of see is this mischaracterization or unintended characterization of intangible assets. And clearly the ATO's approach is to invest in educating taxpayers about what documentation we will be seeking in terms of how we would go about looking at that very question that we spoke about. And I think we are largely informed by what we think our court system will look at and how they will approach the issue. And I think our PCG, some of the taxpayer alerts and now this ruling is really saying to taxpayers, well, initially we're going to look at the legal form. So that's one of the risk factors in the PCG. And then another risk factor in the PCG is we're actually going to look at how you've identified the intangible assets and the functionality that sits around those intangible assets. And then we'll look at the broader context once we sort of get comfortable with those elements. Now, again, that aligns to a broader intangibles principled approach. But we have found that that's sort of the most efficient way for getting to this apportionment question. And going back to the apportionment issue, I think what we would just say is that we're not immediately defaulting to a quasi-transfer pricing approach. What we are doing is really trying to step through those two processes that I just spoke to actually characterise the asset or the function or looking at the legal form arrangement, rather than defaulting to, well, we think that we can find a comparable transaction and the comparable transaction pays a 4% royalty or whatever it well may be. So we recognise that there might be a role for such transfer pricing approach, but our preference is and our approach will be to stick to the facts and circumstances of the case, adopting our principled approach and trying to arrive at what we think is a reasonable apportionment of the amount.
Thanks, Chris. And I think certainly one of the most challenging areas around this, and I think something that's been triggered by a couple of the questions that we have coming in. So I'll flag to everyone, obviously we still welcome questions. I'm getting through a few of them through a private message. I will say, please keep the questions general enough that they can be answered by the panel without going specifically into your own circumstances, because I think that's probably something we can't do today. Before I come to those questions, I'm just going to throw one last issue out there for Megan and Miranda, which is how this fits into the bigger picture around the world right now and what we're seeing in terms of the global reforms culminating in the OECD's Pillar 1 and Pillar 2 proposals, as well as even more recent developments that we've seen. And really, how does this all fit together as one big puzzle? Megan?
Thank you. And I'll go quickly, watching the clock so we have time for questions. But, I've mentioned this before, but as far as we know right now, we're not aware of another jurisdiction that has implemented this approach to the classification of certain software payments. There are kind of other instances around the world that I think are relevant to this, and I'll get to the OECD product in a moment. But want to flag in one that the Indian Supreme Court earlier this year actually reached the opposite conclusion as that what was included in the draft taxation ruling. There had been a long-running issue related to the characterization of payments made by Indian customers to non-resident suppliers for the use or resale of computer software and how those would be characterized. And so in the Indian Supreme Court's decision, they found that the amount paid by resident Indian end users to non-resident computer software manufacturers for the use or reuse of computer software through end user license agreements should not be characterized as royalties. So that was one instance that happened earlier this year. The other place this topic has come up, though, several times now is in the UN Tax Committee. So the UN Tax Committee had approached this issue in the most recent 4-year term, which ended earlier this year. We expect to see further consideration in the new term that began last week. ITI, we had participated in 2 public consultations on the matter over the last year, both of which had asked stakeholders to comment on whether the UN Model Double Taxation Convention should be amended to include software payments. And the definition of Article 12 royalties subject to gross basis withholding. Again, we hold many of the same policy concerns about this approach from the principled global tax norms perspective. But one note I want to bring up of particular relevance to the UN Model Tax Convention would be concerns about significant ambiguities related to the interactions between Article 12, Article 12A, and Article 12B, which was adopted in the most recent term. Setting aside the UN, I do want to get to the OECD project real quick. So as many of you know, back in 2017, the OECD G20 Inclusive Framework restarted its work to address the tax challenges arising from the digitalization of the global economy. So collectively known as the two-pillar approach, you have Pillar 1, which would allocate new taxing rights to market jurisdictions for certain companies and would provide for the removal of unilateral tax measures on all companies. And then Pillar 2 would act as a global minimum tax on corporate profits. To start, I want to be exceptionally clear that we do not expect outcomes from the inclusive framework to affect the international norms for the characterization of software payments. So with that disclaimer out of the way, though, there are a couple of elements or themes from ITI's ongoing engagement with the inclusive framework that I see as relevant to this discussion. First is the role of principles. You have international tax principles such as taxing income once, simplicity, looking ahead, so prospective, application and fairness. And those have driven much of our analysis and feedback as the inclusive framework has published new results or new outcomes. And that brings me to the next point, really, is looking at what brought us to this stage. And the OECD project is really trying to alleviate fragmentation in the international tax system that's been brought on by unilateral, uncoordinated measures that are designed to operate outside of income tax treaties or bilateral income tax treaties. And these unilateral measures, digital services taxes, upend global tax norms as laid out in the OECD commentary. And the proliferation of measures, these can lead to double or multiple taxation, especially where the scopes may differ. For example, when you have an equalization levy in India that has a much broader scope than perhaps that may overlap with what you're seeing out of France or Austria, one of the European DSTs. Now, while the global minimum tax in Pillar 2 has captured much of the headlines, many of the inclusive framework's more, I would say, fundamental commitments have focused on easing that fragmentation and making for a more predictable and sustainable international tax landscape. And part of that, a huge part of that, are commitments to not only withdraw relevant unilateral tax measures. These are the ones that are operating outside of bilateral tax treaties, operating on a gross basis, and to refrain from the introduction of new ones. We also saw a moratorium in the most recent October statement that commits participating governments not to impose any newly enacted measures from now into the coming to effect of a multilateral convention or the end of 2023. And then we also have the transitional arrangement announced last week between the United States, Austria, France, Italy, Spain, and the United Kingdom. Again, looking at a transitional arrangement to provide for the removal of those digital services taxes as governments are looking to implement the outcomes of the inclusive framework. And maybe the final point I'll make of where I see kind of maybe things to be learned maybe from the inclusive framework negotiations is that really the sheer totality of what's being advanced through the inclusive framework, both in terms of precedent policy-wise, but also administration. These are arguably the most significant changes to the international tax system that's been in place since the League of Nations. Tax authorities and companies alike are working through the technical details and putting systems in place to prepare for as the finalization of details happens. Now, beyond the question of like why, Chris talk through why ATO is moving forward with this approach at this time that deviates from the global norms for taxing software payments. But there's also the question of why now. We're not aware of any domestic tax or copyright law changes which might necessitate a reversal of previous guidance. And so it's unclear why this is moving forward right now when no circumstances have arisen that could warrant such changes. And this is especially true given how much energy tax authorities and companies alike are committing to reaching and implementing the reforms being achieved right now through the inclusive framework. So I'll turn it over to Miranda that was a bit of a around the world.
Thanks. And Miranda, I might just ask, we keep this very brief. I'm conscious of the clock right now.
No, that's right. And look, I just two comments, I suppose. One is that it is interesting to think about all of this in the context of Pillar 1. And of course, the Pillar 1 is a change in is a focus on net taxation, right? Taxation of business profits, but changing the way we think about the nexus, right? And it's the nexus that is potentially an issue, right? When we're talking about net taxation of PEs as opposed to gross royalty withholding taxes. I suppose the other comment, just in response to Megan's observations about digital services taxes, is that if we are moving to a stronger multilateral agreement or approach between countries to, as you say, stick within a framework, stick within a treaty-based regime that has some certainty, I think it's not going to eliminate the pressures that we see, right, for nexus and source taxation, not just from countries like Australia. And so, ironically, we might end up seeing more interpretive uncertainties and approaches within that treaty framework rather than outside it, because of trying to kind of ensure that things are within the framework. Leave it there, Ben, and let you have some questions.
Excellent. Thanks, Miranda. It probably won't surprise anyone that most of the questions I'm receiving are directed at Chris, but I might start with one that jumps us well outside the income tax sphere that we've been dealing with, and ask whether the ATO intends to maintain a different position for GST. And the question notes that most of the GST rulings refer back to the 1993 ruling and adopt an approach that might not be characterised as a rights-based approach. And I guess the query is whether the GST treatment is expected to significantly change as a result of the rights-based approach.
And I don't think it will, but again, I think the question is well, what transaction are you positioning that equally applies to the new ruling and then equally applies to a GST tax in terms of where you've previously been applying 9312. So there has been thought to this, but I think it's a difficult question to answer because I don't know the context in which the transaction is cast, and I think that whilst there might be some scenarios where there might be a need to sort of have a discussion and make sure it's still aligned, I don't see adopting an approach where you identify what's being paid and you characterise the amount for what's being paid as being largely inconsistent with the GST approach.
Thanks, Chris. The next one I've got more of a process question, and you may well be limited in what you can say around this, but the question, and I'll summarise this, asks to what extent has the ATO engaged with other areas of government around this position, noting that it's Treasury ultimately responsible for the negotiation of tax treaties, and that the Department of Foreign Affairs and Trade may well have a significant interest in this space.
Yeah, and I'm really confident that we have engaged with a lot of people in terms of industry, other jurisdictions, internal, other Australian government agencies. So I don't lie there at night thinking, oh, we should have spoken to that person. I lie there at night thinking we are speaking to that person and we're speaking to them again tomorrow. So confident that this is not going to come as a surprise to anyone. And I think whilst we have had a lot of consultation, I really think and really am confident that consultation that we have had will make its way into the next version of the ruling and actually will detract from some of these issues. And I think sort of what we, even picking up from today, I think what we will sort of really clarify at the front even further is that we're not looking at a transaction, and we're not looking at a transaction from the end user perspective. So we're not looking at what is the nature of the payment from an end user to the distribution entity. That's not the transaction that we're looking at. That's not the transaction that we're characterising. And I think whilst that might be certain in some people's minds, it's very important that that's clear in people's minds that we're looking at an entity which is saying that it is paying something to the copyright owner, and we're looking at that transaction and we're saying, well, what is the nature of that transaction? Now, I appreciate that some of the OECD guidance says, well, you do have to have regard to, and particular 14.4 might say, well, it doesn't matter if the end user acquires the product and the form that the end user acquires the product. But I think what should be very clear in people's mind is that the transaction that we're looking at is the transaction between a distribution entity saying that I am paying for something from another entity which presumably owns the copyright.
Thanks, Chris. And I might finish with the question I've received that's perhaps a very natural closing question for you in terms of, well, what happens next? What are the expectations around timing from the ATO in terms of finalising the guidance or any further consultation?
Sure. So, so in terms of where we see the sort of the timing of the next draft, I think we would say that the timing of the next draft will be sort of early, but not too early, 2022. We're anticipating that, given current circumstances here, that early 22 in terms of January will be very, very quiet. So we're anticipating in terms of landing at sort of the end of January, and we would be looking to have again as an extended consultation process. So we did that the first time in terms of we sort of extended the period in which we would receive submissions and have discussions, and we'll be adopting the same approach again.
Excellent. So I'll conclude by both thanking the panel. Your contributions, I'm certain, will be appreciated by everyone in the audience, and thanking our audience for both their time and their excellent questions. My sincerest apologies to those that we didn't get to cover today in light of the time. And with that, I'll bring this session to a close. Thank you.